When you are dealing with property management, it is important that you know your rights as an owner of real estate investments and what your rights are. But you should definitely understand what the rights are from the tenant's perspective. More often than not, when I am working with clients who've gotten themselves in trouble, or if I run into people in the courts who've gotten themselves into trouble, it is because usually they are not well versed in landlord tenant law, and they haven't taken the time to really understand what tenants' rights are, how they can be applied, and it can be quite costly for a landlord to make a mistake when dealing with the tenant properties and their rights, things like entering the property, giving proper notice, what your rights are for non-payment of rent. So in Pennsylvania, as in many states, the tenants are protected by a robust set of rights to ensure fair treatment, habitable living conditions, and clear lease terms. If there's one thing Pennsylvania likes, it is plain language. There's a plain language lease law. So they want things to be very clear and something that tenants can understand when they're signing their lease. I have always taken from a fair housing perspective and equal rights that we treat everybody equally. We really are focused more on one color, and the color is green, money, or gold, I guess you could say. But owners need to understand, like, it doesn't matter about color, disability, familial status. That's a big one because that's even changing right now. National origin, religion, race, or sex. None of these things should matter to you as a landlord. What should only matter is the quality of the candidate, their job strength and length and history, and the likelihood of their credit if they will pay. That is the most important part, is will they pay? And in recent years, we've seen increased commitment to housing equality, especially concerning things like disability, race, and familial status. The family status is a big one because the definition of what a family is changing. And some areas still have this like 3 non-related people can't live, but how do you define non-related in today's day and age? So something for landlords to think about. Something else is marketing and advertising rights. Landlords and property managers, anyone putting out property for rent, have to ensure their marketing practices comply with the Fair Housing Act, which is focusing on the amenities and features of the property rather than any discriminatory factors. And that is just one easy way to keep yourself out of trouble. When it comes to rights regarding credit and consumer checks, under the Fair Credit Reporting Act, landlords must obtain a tenant's permission before running a credit report. If a landlord takes adverse actions based on these reports, such as requiring a co-signer or increasing the security deposit, they must inform the tenant and provide an opportunity to review and dispute the report. And we have no problem with that. We run full background credit reports, I think they're TransUnion, so it does a full, complete background. Some credit checks only give like grading reports or kind of information. We do thorough actual credit pulls. We want to see those histories. And if if an applicant ever asks for a copy of their credit report, we're happy to provide that to them. Now, when it comes to their rights on the lease, security deposit, this gets a lot of owners in trouble. You need to understand that security deposits are not your money. They are the tenant's money, and it's money that is being held by you. And after 2 years, it is required to earn interest. And for a while, that wasn't a big deal when interest was 0.01%, but now we are seeing 3, 4, 5% interest rates in savings accounts. So it's time to go back to putting tenants' monies into interest-bearing escrow. So right now, Pennsylvania can charge up to 2 months' rent as security deposit for the first year and 1 month's rent thereafter. And they're counting that as including pet deposits would be considered part of that rent. So technically, they're saying after the first year, even the pet deposit is supposed to be returned I'm not sure how I totally feel about that, and there's no legal advice here. I'm just letting you know that first month's, last month's security, we're okay with that. Technically, after the first year, it really should just be 1 month's security deposit. And this is why, by the way, we cannot do things like take someone who says, I'll pay 6 months or a year up front. It's just something that it can't do. That be considered you're asking it as a deposit because you wouldn't accept them otherwise. Now, another one that we're starting to see pop up is lead. Lead just loves to show up. Properties built before 1978, landlords must provide tenants with lead-based paint disclosure and an EPA-provided pamphlet. We do this as part of all of our leases, a standard to give those forms out. We don't often come across lead problems. Most of the buildings have been renovated over the years or have been encapsulated with so many layers of paint. But the EPA is coming down on this for renovations on properties. So it's something to be thinking about. If you're doing massive renovations on your properties, you need to take into effect if your property was built before 1978, and especially if it's tenant occupied, you could find yourself in a situation where you're going to have to do mitigation work to protect the property and or the tenants from lead poisoning. Something to think about. Another thing that we are seeing comes in are occupancy limits, and this one can be it can be tough because you've got HUD that gives one set of guidelines. You might have local laws that want to do something else, but typically the standard is 2 people per bedroom. So if a 2-bedroom property, it's a 2 plus 1, 2 plus 2 per bedroom plus 1 in the living room. So technically a 1-bedroom would be a 2 plus 1, 2 in the bedroom, 1 could be in the living room. If it's a 2-bedroom, they want 2 plus 2 plus 1. I don't know how I feel about that. I don't know how I feel about lots of units having tenants in the living room, but from the way we've been explained is if they are qualified, they can afford to live there peaceably. It's not your concern how they break that up as long as they don't exceed occupant limits. Your mileage may vary on that one, so do your due diligence. When it comes to the leases, the tenants have rights as far as the lease term compliance. So any lease clause that you write in there, if it violates the law, it's invalid. So you can write in there that, hey, if the tenant breaks the lease, they're going to owe me rent through the end of the year, the term of the lease. But the law is very clear that you cannot enrich yourself. If someone moves out, you're lucky if you're going to get 60 days worth of rent. Some judges will give you up to 90 days, but after that, their attitude is you should have re-rented it, and landlords are not allowed to double dip. One of the things with lease compliance that we're starting to see is accommodating service animals. Now, when they're trained service animals, when you think of a C&I dog, somewhere where the animal's been trained, I think most of us think that is a standard type of service animal. They are treated like people. They are not treated like animals. You can't charge pet deposits. But when you get to emotional support animals, it's a little grayer because they're not animals that have been trained in a service, so they're not service animals. And there has been an uptick in people submitting fake letters that you can buy on the internet saying, hey, this is an emotional support animal. So this one is still a gray area, and we will be following up with more information on this. But it's definitely something that you're going to be facing, and it's a challenge that you're going to be seeing. So it's something you should be thinking about when you are renting properties. Okay. And then even if there is not a lease, some of the old school landlords still worked on verbal leases, handshake deals. The way it works is if there's no written lease, it's an implied month-to-month lease in Pennsylvania. If there's no written lease, it's an implied 30-day lease, month-to-month, with 30-day notice. So even if there is no lease, the tenant can't say, well, there's no lease, so I'm not responsible. And not having a lease does not give either party a free-for-all. They still have to follow the rules and laws of Pennsylvania when it comes to eviction or collection or things like that, or accessing the property. Now, once the tenant has moved into the property, their rights continue. And one of those is they have a right to quiet enjoyment. Right? They have the right to peacefully enjoy that property without unwarranted landlord intrusion. Now it says landlords must provide reasonable notice, typically 24 hours. And this is an interesting one because we've seen over time that people will say, oh, you must reply, you must give me 24 hours notice. And I don't believe there's any law anywhere that is a requirement for 24 hours notice. It's typically encouraged for 24 hours notice unless there is an emergency. Now, as a courtesy to tenants, I would often suggest that you try to give them 24 hours notice, or at least, previous day for following day notice. There are going to be times when you can't, but you have to put yourself in the tenant's perspective and remember you are violating their space. You're coming into their property. This is their home. We try to mitigate that as much as possible, but they have a right. They have a right to peaceable enjoyment. You should give them the notice and you should respect that whenever possible. Okay. They also have a right to a safe and habitable home. Tenants are owed that landlords must ensure the properties are safe and habitable. We are not fond of working with landlords who refuse to repair their properties. If you don't have the money to run your business successfully, then you should not be in this business. If you're going to rent a property out, it has to be safe, it has to be habitable, it has to have functioning utilities, secure structures. You must be able to lock the doors, the windows. And at the same time, we tell tenants we are unable to take care of problems if you don't let us know. So some repairs are reasonable and will get taken care of in a time frame. Others are actual emergencies and need to be taken care of in a timely manner. Now, here's something I wish that they would teach in schools, which is, listen, tenants have a right to withhold rent. There's nothing wrong with that. In 15 plus years, if I had tenants withhold rent while a repair took longer than normal, absolutely. And we always guide them on, you want to follow getting an escrow account, putting money in that escrow account and providing copies of that to the landlord or property manager in a timely manner as if you were paying your rent. This goes a long way for tenants, allowing them to withhold rent if the landlord fails to make necessary repairs. And this has happened. Sometimes tenants withhold rent because they believe the repair has not been taken care of, and then you have to go to court to prove that it has. Other times they respectfully and rightfully withhold rent because an owner has dragged their feet. Even with property management, there's times when we have had to work with owners who might be under a delay financially, and this can cause delay. Tenants have a right to do that. And it's not meant to be punitive to them. It's not meant to be punitive to the landlord or property manager, but it is the one way that a tenant has a way to exert rights to show that this needs to be fixed. Okay. The right to repair and deduct. Now, tenants can make essential repairs and deduct the costs from their rent. We would obviously want them to document this as much as possible, but they must have notified property management or landlord in advance. They have to have communicated this, and there has to be a reasonable amount of time that passes that has not been taken care of. Now, as property management, we are never going to allow that to happen. If we need to take care of the repairs, we're going to get them taken care of. But have we heard stories of landlords who did not do them in a timely manner, and the tenants took it into their own hands? Yes, and rightfully so. If a reasonable amount of time has been provided, it should be fixed. Landlords have to also give notice to tenants. They do need to provide notice if they do not intend to renew a lease. Now, there are automatic termination clauses in some leases. Some are automatic month to month at the end of the lease. Some are automatic year to year. But either way, if you're not going to renew, it is only good common courtesy to let your tenants know that you're not going to renew their lease. I would recommend giving them at least 60 days notice. Put yourself in the other person's perspective and think about how difficult it can be to find new housing. It's going to take time. So if I can give people 60 to 90 days notice, I think that's the best way to help them in their search for a new property. And then finally, we get to security deposits, returning of security deposits. When it comes to security deposits, landlords have to return them within 30 days, along with an itemized list of any deductions. And yes, tenants can sue for double damages. It might even be treble. I can't remember which. It's definitely at least double. But that 30 days, that is not to be messed with. And it can be difficult because some repairs can take longer to get. During the pandemic, when people if they were moving out, it was taking longer to get people out there to get quotes. And again, these are for damages. We're not talking about going after tenants for things like scuff, things like that. You want to make sure that whatever charges you're putting on a tenant's move out list, that you could stand before a judge and you have the receipts to show the pictures to show what the damages were, and the receipts to show what the actual charges were from the contractors. Again, the security deposit is not meant to be punitive. You're not trying to get that out of a tenant. I would like to return as much of the security deposit as possible. Very rarely do we keep an entire security deposit. There are some built-in cleaning things that we put in our security deposits that will come out when a tenant moves out. But we, again, put that all right up front. They see it. It's highlighted. It's initialed. Don't mess with security deposits. That's what I can tell you. Okay. So thank you very much. Those are tenants' rights in Pennsylvania. Other states may vary. Please do not take any of this as legal advice. It is just good practice that I've been working for 15 years. When in doubt, consult an attorney or seek legal counsel if you have any questions about what rights you or your tenants may have.